What you know, alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Still Tuesday, December 23rd. We're going to knock out the rest of the state's response to Lori Daybell's appellate brief. By the way, a lot of people have said, I thought I was subscribed to you, but I'm not. So if you're watching on YouTube, click and make sure it says you're subscribed. If you're watching on your TV, you can tap to go up, and then it should have the option there to subscribe. Also, I'm not sure if hyping a video costs money. But if you like this video and hype it, it helps to get my channel out to people who don't know I exist. I appreciate all y'all. So the next part of this response is Vallow has failed to show the district court erred by overruling Vallow's pretrial objection to the state's proposed 404B evidence, which is prior bad acts. A, the introduction. The district court properly overruled Vallow's objections to the state's proposed 404B evidence. The time between the state's notice and trial was reasonable, especially considering that Vallow's defense team had the information from early in the case. The state demonstrated the proposed evidence was relevant for purposes other than propensity, and the risk of unfair prejudice did not substantially outweigh the probative value of the evidence. On appeal, Vallow limits her argument to circumstances surrounding the murder of Charles Vallow and the attempted killing of Brandon Boudreaux. She also limits her challenge to the district court's pretrial ruling, as she does not cite or rely on any objections made for trial. The district court properly rejected Vallow's pretrial objections. Part B, the standard of review. The trial court has broad discretion in the admission and exclusion of evidence. They cite State v. Folk. Idaho's appellate courts defer to a trial court's factual determination that a prior bad act had been established by sufficient evidence if that finding is supported by substantial and competent evidence on the record. They cite State v. Pramer. Whether proposed Rule 404B evidence is admissible for a purpose other than propensity is given free review, while the determination of whether the probative value of the evidence is substantially outweighed by its potential for unfair prejudice is reviewed for an abuse of discretion. They cite State v. Grist. In determining whether a trial court has abused its discretion, the appellate court evaluates whether the trial court, 1, correctly perceived the issue as one of discretion, 2, acted within the outer boundaries of its discretion, 3, acted consistency with the legal standards applicable to the specific choices available to it, and 4, reached its decision by the exercise of reason. And they cite several cases. The next section, the district court did not err when it overruled Vallow's objections to the state's proposed 404B evidence. The state has an obligation in any criminal case in which it intends to use evidence under Rule 404B to provide notice to the defense reasonably in advance of trial. Under the rule, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character, but may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. When determining the admissibility of 404B evidence, the trial court must engage in a two-tiered analysis, and they cite State v. Anderson. The first tier has 2 steps. 1, the trial court must determine whether there is sufficient evidence to establish the other crime or wrong as fact, and 2, the trial court must determine whether the evidence of the other act would be relevant to a material and disputed issue concerning the crime charged, other than propensity. The second tier requires the trial court to engage in a Rule 403 balancing test to assess if the risk of unfair prejudice substantially outweighs the evidence probative value. Vallow does not challenge on appeal that there was sufficient evidence to establish the state's proposed 404B evidence as fact. As to the rest, the district court conducted the appropriate analysis and properly found that 1, the state provided reasonable notice, 2, the proposed evidence was relevant for a permissible purpose, and 3, proposed evidence passed the Rule 403 balancing test. So, Rule 403 allows judges to exclude relevant evidence if its usefulness or probative value is significantly outweighed by the risk of unfair prejudice, confusing the issue, misleading the jury, causing undue delay, wasting time, or presenting cumulative evidence, acting as a balancing test to ensure fairness in trials by keeping out overly prejudicial or time-consuming information. Back to the filing. The next section, the district court properly found the state provided reasonable notice of the proposed Rule 404B evidence. Rule 404B requires the state to provide notice of its intent to use evidence under the rule reasonably in advance of trial. It goes without saying that the purpose of this rule is to reduce surprise and promote early resolution on the issue of admissibility. It says, see State v. Sheldon. When determining whether the state provided reasonable notice, district courts may properly consider when the defense first learned of the information. And it says, see State v. Jones. Explaining defense may learn of the information through discovery, thereby reducing the chance of surprise. In a footnote, it says the trial courts of this state have relied on this rationale as noted in at least 2 appellate decisions. In State v. Naranjo, observing district court found disclosure reasonable where defendant had previously been made aware of proposed evidence from a disclosed police report. In State v. Rawlings, finding district court implicitly ruled 404B evidence notice timely and noting that the prosecutor provided the relevant information in discovery months before the trial. The Idaho Court of Appeals has expressly relied on this rationale in an unpublished opinion, which the state cites only for this court's information and not as authority. They cite State v. McHale. They found the 404B evidence disclosure provided 10 days before trial reasonable because the state previously provided the evidence in discovery, meaning defendant had a long-standing knowledge of the evidence's existence. Here, the district court properly found the state's 404B notice was provided reasonably in advance of the time of trial. The time between the formal 404B notice and the trial was 40 days, from January 26 to March 27th. That amount of time is reasonable on its face, even in a complex case. They cite U.S. v. Evangelista, 10 business day deadline imposed in multi-defendant case, and then U.S. v. Williams, 10-day deadline imposed in 2-defendant multi-count money laundering case. U.S. v. Alex, 7-day deadline imposed in multi-defendant multi-count racketeering case, and U.S. v. Green, 30-day deadline imposed in 26-defendant multi-count drug and racketeering case. Think her argument's going to fall a little flat. But the district court gave 2 other reasons for its decision as well, both of which cut against Vallow's claim that her attorneys were surprised by the formal motion filed on January 26th. On December 27th, a full month before the notice was formally filed, the state informally notified the defense by email that it would be filing a 404B notice. And more importantly, the state has turned over the subject evidence well ahead of the filing of the formal notice meeting. These facts have been in possession of the defense since early on in the case. Vallow has not challenged those factual findings on appeal. The district court properly found that the timing of the state's disclosure was reasonable because Vallow's attorneys could not have been surprised by evidence that had been in their possession since early on in the case. Vallow vaguely asserts she did not have enough time to prepare and to meet the evidence without any explanation as to what her attorneys might have done differently had the notice been provided earlier. She also argues the state was hiding the ball, an accusation the district court rejected on the common sense basis that providing defense all the proposed evidence early in the case would be a strange way of intentionally hiding the ball. Vallow has thus failed to show the district court abused its discretion when it found the 404B evidence was disclosed at a reasonable time before trial. The next section, the district court properly found the state's proposed 404B evidence was relevant for a purpose other than propensity. To be admissible, evidence must be relevant. And they cite Idaho Rules of Evidence 401 and 402. Evidence is relevant if A, it has a tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. They cite State versus Garcia. Evidence of other crimes, wrongdoings, or acts is not admissible to prove a defendant's criminal propensity. However, such evidence may be admissible for a purpose other than that prohibited by Idaho Rules of Evidence 404B, and that is State versus Truman. Under Rule 404B, evidence of a prior crime, wrong, or act may be admitted to prove, among other things, motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. The rule represents one of inclusion, which admits evidence of other crimes or acts relevant to an issue in the trial, except when it tends to prove only criminal disposition. And they cite State versus Salinas. Of course, evidence of a prior crime, wrong, or act may implicate a person's character while also being relevant and admissible for some permissible purpose, such as those listed in the rule. They cite State versus Folk. However, such evidence runs afoul of Rule 404B only if its probative value is entirely dependent upon its tendency to demonstrate the defendant's propensity to engage in such behavior. As the district court concluded, the state's proposed evidence was relevant to plan, preparation, knowledge, or identity. Evidence is relevant to prove a common scheme or plan where the commission of two or more crimes is so related to each other that proof of one tends to establish the other. Knowledge, identity, or absence of mistake or accident. They cite State versus Levitt. The events must be linked by common characteristics that go beyond merely showing a criminal propensity and instead must objectively tend to establish that the same person committed all the acts. The state sought to introduce evidence showing a pattern of how Vallow and Daybell operated to get what they want. Daybell would pronounce someone had a dark spirit and instruct his followers that the problem could only be solved by killing the body of the person. The state had evidence that Daybell and Vallow had utilized this method on 2 occasions in the recent past to target individuals from whom they could materially profit. First, with Charles. Daybell pronounced Charles had a dark spirit. Daybell and Vallow spread that information to others, including Alex. Alex then killed Charles under incredibly suspicious circumstances, and it just so happened Charles had a $1 million life insurance policy that Vallow believed she would inherit after his death. Next, with Brandon, Daybell pronounced Brandon had a dark spirit. Daybell shared that information with others, including Alex. Alex then shot and tried to kill Brandon. Brandon had a life insurance policy that Melanice would have benefited from upon his death, and it just so happened that Melanice provided financial assistance to Vallow. As the district court recognized, this pattern was relevant to Vallow's case because the state had evidence showing the same pattern with the 3 victims in the state's case. Daybell pronounced Tammy, JJ, and Tylee all had dark spirits. Daybell and Vallow shared that information with others, including Alex. Tammy, JJ, and Tylee were all killed under suspicious circumstances, and Vallow and Daybell would benefit financially from each of their deaths. That pattern and its repeated use, including in the instant case, was more than sufficient to establish relevancy based on plan, preparation, knowledge, or identity. Vallow attempts to counter the district court's reasoning by whitewashing it. The state proposed evidence is not relevant, Vallow claims, because, even under the state's theories, none of the victims were physically killed the same way. Charles was somehow lured into a trap, then shot under the guise of self-defense. The attempted shooting of Brandon Boudreaux was from the back of the vehicle, and the victims in this case were all killed in different ways. But the obvious pattern, and the one the district court relied on to find relevance, was not how the individuals were physically killed, but the plan leading up to their death or attempted death. In all instances, Daybell labeled the victims as dark, and the plan for Charles and Brandon mirrors the castings alleged to have been performed on JJ, Tylee, and Tammy. a self-proclaimed religious leader with a small but committed following who targets individuals by labeling them as dark spirits before utilizing his love interest's assigned protector to kill his targets in the hope of obtaining a financial benefit is about as unique of a calling card as one can have. The district court properly relied on these similarities to find the state's proposed evidence relevant in Vallow's case. In a footnote, it says the state has limited its response to the 404B evidence related to the killing and attempted killing of Charles and Brandon because those are the only specific categories of evidence Vallow challenges in her opening brief. The next section. The district court properly found the risk of unfair prejudice did not substantially outweigh the probative value of the state's proposed evidence. Rule 404B also requires the trial court to engage in a Rule 403 balancing test to assess if the risk of unfair prejudice substantially outweighs the evidence probative value. And they cite State versus Anderson. Rule 403 does not require the exclusion of prejudicial evidence. State versus Rawlings says most evidence offered to prove a defendant's guilt is inherently prejudicial. The rule only applies to evidence that is unfairly prejudicial because it tends to suggest that the jury should base its decision on an improper basis. The rule suggests a strong preference for admissibility of relevant evidence. The district court walked through this process for each category of the state's proposed evidence. The district court recognized, as explained above, that the similarities between the killing of Charles and attempted killing of Brandon and the killings of the victims in this case made the state's proposed evidence highly probative. It also recognized it could mitigate the risk of prejudice by properly instructing the jury on the proper use of the evidence. And where that would not be sufficient protection, the district court excluded the state's proposed evidence. The district court did not abuse its discretion. On the issue of unfair prejudice, Vallow takes a flawed approach. She argues only that the danger of unfair prejudice was extreme because about 1/3 of the witnesses testified partially or entirely to what the state contended was criminal activity or bad acts in Arizona. But the amount of 404B evidence, especially in terms of the total number of witnesses, could not possibly have been known by the district court when it made its pretrial ruling that Vallow challenges on appeal. They cite State versus Redu, emphasizing the abuse of discretion standard applies to the record before the district court when it ruled. And they cite State versus Gray, which says, if the evidentiary challenge on appeal is not the same as that presented in the motion in limine and no objection during trial raised the specific basis, then that issue was not preserved for appeal. In fact, the district court explained to the defense that any ruling here as to 404B is limited in scope, just as to 404B, so it was not ruling the evidence comes in. And it reminded the defense that any evidence is still subject to any of the other evidentiary objections that could be raised, such as hearsay, foundation, etc. The unfair prejudice Vallow now asserts could not have been known until the state presented its evidence at trial, at which point the defense could have objected. But Vallow has not cited any objection to such prejudice in the record at trial and has challenged instead only the district court's pretrial determination on the state's proposed 404B evidence. She has failed to show the abuse of discretion. The next section. Vallow has failed to show the district court erred when it denied her motion to dismiss on the basis that her speedy trial rights were violated. The introduction. The district court properly found Vallow's rights to a speedy trial were not violated. Through the time between the indictment and trial was nearly 2 years. Most of the delays were attributable to Vallow and included 2 stays because she had been deemed incompetent. Given the complexity of the charges against, the large amounts of discovery, and the need to prepare for trial, the district court properly rejected Vallow's statutory and constitutional claims as to speedy trial. The next section is the standard of review. Whether there was an infringement of a defendant's right to a speedy trial presents a mixed question of law and fact. And they cite State versus Davis, which says the appellate court defers to the trial court's finding of fact that are supported by substantial and competent evidence, but freely reviews the trial court's conclusion of law. The next section, Vallow's rights to a speedy trial were not violated. The district court did not err when it found no violation of Vallow's rights to a speedy trial. All criminal defendants in Idaho have a constitutional right to a speedy trial pursuant to both the U.S. Constitution and the Idaho Constitution. The right to a speedy trial under the U.S. Constitution is assessed by the balancing of 4 factors. 1, the length of the delay. 2, the reason for the delay. 3, whether the defendant asserted the right to a speedy trial. And 4, the prejudice to the defendant. They cite Barker versus Wingo. This approach has been adopted in Idaho for determining whether a speedy trial violation has occurred under the Idaho Constitution. They cite State versus Lankford. Thus, the U.S. Constitution and the Idaho Constitution are both interpreted under Barker. Criminal defendants in Idaho also have a statutory right to a speedy trial pursuant to Idaho Code. However, trials can be delayed under the statute for good cause, and good cause exists when there is a substantial reason that rises to the level of legal excuse for the delay. Predictably, the case-specific balancing test adopted by the Idaho Supreme Court has resulted in a wide variety of permissible lengths of delay before trial. Delays from 15 months, and it says see State versus Ish, to 17 months in State versus Lopez, and in Lankford, 2 years. These delays have all been found permissible. Applying the Barker factors to this case and considering all the circumstances for good cause under Idaho Code shows no violation of Vallow's speedy right trials. So in the Lankford case, this was in Idaho where a Texas couple were beaten to death while camping in Idaho. And this case is unique because Mark Lankford was tried and convicted multiple times, actually 3 times. For the 3rd conviction, this is where the speedy trial claim comes into play. He argued the long delays between trials should have meant his indictment or prosecution was stale and therefore dismissed. But the Idaho Supreme Court was like, nah, we disagree with you. They found that most of the delay was caused by Lankford's own legal actions, including appeals and motions like firing his attorney, trying to find new counsel, and litigating pretrial motions. That reduced the force of his speedy trial claim. So in other words, you can ask for a speedy trial, but you can also shoot yourself in the foot by doing things like that. Applying the Barker factors to this case and considering all the circumstances for good cause under Idaho Code shows no violation of Vallow's speedy trial rights. So what are the Barker factors? These are the 4 different factors that the court balances when determining if somebody's right to a speedy trial is violated. The first is the length of the delay. The second is the reason for the delay. The third is the defendant's assertion of the right, and the fourth is the potential prejudice to the defendant. The first factor, the length of delay, favors Vallow only slightly. Under the Sixth Amendment, the period of delay is measured from the date there is a formal indictment or information, or else the actual restraints imposed by arrest and holding to answer a criminal charge. They cite Lopez. Under the Idaho Constitution, the period of delay is measured from the date formal charges are filed or the defendant is arrested, whichever occurs first. The delay that can be tolerated for an ordinary street crime is considerably less than for a serious, complex conspiracy charge. And they're citing Barker there. Vallow was indicted on May 24, 2021, and the trial started on April 3, 2023. She was charged with a massive conspiracy that resulted in the deaths of multiple people. A delay of 679 days is presumptively prejudicial and weighs in favor of a speedy trial violation. It says, see Ish, collecting cases and finding delay of 448 days was presumptively prejudicial, but the delay was not unreasonable given the complexity of the charges, so this factor favors Vallow only slightly. They cite U.S. versus Lewis, which says finding length of delay of 2 years only slightly favored defendant in complex case. The second factor, the reason for the delay, weighs heavily against Vallow. Pretrial delay is often both inevitable and wholly justifiable. different weights attached to different reasons for delay. They cite State versus Avila. A deliberate attempt to delay the trial in order to hamper the defense should be weighed heavily against the state. A more neutral reason carries less weight, but nevertheless slants against the state. And defense-caused delays are not weighed against the state. The longest delay by far was caused by the defense for the purpose of determining Vallow's mental competency to stand trial. Citing U.S. versus Sutcliffe, excluding period of mental competency proceeding in speedy trial calculation, either as necessary in the interest of justice or attributable to the defense, Vallow's case was stayed at the defense's request on 2 occasions to address Vallow's mental competency to stand trial. From May 27, 2021 to April 11, 2022, and from October 6, 2022 to November 9th. Those are 353 days that are either attributable to the defense or, at the very least, not attributable to the state. They cite Vermont versus Brillion, holding delays by defense counsel, even public defenders, attributable to the defendant for purposes of speedy trial. The next longest delay was at least partially attributable to the defense. The defense's motion to stay the case a second time for Vallow's mental competency necessarily vacated the January 9th, 2023 trial setting. The 145-day delay between the end of that stay on November 9th, 2022, and the start of the trial on April 3rd, 2023, resulted in large part from Vallow's successful effort to change venue. The transfer from Fremont County to Ada County required complex, multifaceted planning and case administration that must be taken into account. The district court immediately began the preparations to schedule the trial to the host county after lifting the stay. But Vallow's requested change of venue came with hurdles that necessarily required delay. Security, staffing of personnel, jury commissioner preparations, and designation of physical accommodations for a large jury pool and courtroom at the host county's location have all factored into the time frame that was determined to be the earliest feasible date to conduct this trial in Boise. The inevitable delay that accompanied changing venue must be attributed to the defense who moved for the change of venue over the state's objection. And they cite a case Lankford, holding delay caused by defendant's motion to appoint new counsel against defendant because motions of this nature will almost inevitably lead to considerable delays in going to trial. The district court also gave a second reason for this delay, discovery in a complex conspiracy case, and they cite Lankford, finding 2-year delay reasonable in part to allow prosecutors and defense counsel time to prepare for trial. And see also U.S. versus Hall, finding serious, complex conspiracy charge that implicated multiple parties in at least 2 jurisdictions, acceptable basis for delay. In U.S. versus Bakundi, given the complex conspiracy charges at issue here, with large discovery and multiple defendants, a delay of 18 months was justifiable. And they cite several other cases that essentially say the same thing, that the delay they had in their case was justifiable for their own issues. The district court properly relied on the complexity of the case, volume of discovery, and need to prepare for trial to find this specific delay and the overall delay from indictment to trial reasonable. The other delay identified by Vallow is the state's motion to continue the trial from October 11th, 2022 until January 2023 to line up with Daybell's trial. Not only was this 90-day delay relatively minor, but Vallow concedes on appeal it should be considered a neutral factor because the state was trying to avoid improper severance of the case. They cite her appellate brief stating the placing of the cases on the same track for trial does not necessarily weigh in favor of either party. They cite Ruiz, finding delay justified because the reason for the delay in part was to ensure all defendants were tried together. On balance, the reasons for the delay weigh in favor of the state in justifying good cause for the delay attributed to this critical factor. The third factor is the defendant's assertion of a right to a speedy trial favors Vallow as she unequivocally asserted her right to a speedy trial. The fourth factor, prejudice to the defendant, weighs in favor of the state. There are three interests used to evaluate the prejudice factor. Number one, to prevent oppressive pretrial incarceration. Two, to minimize anxiety and concern of the accused. And three, to limit the possibility the defense will be impaired. Citing Ish, the third is the most serious because the inability of a defendant adequately to prepare his case skews the fairness of the entire system. Vallow has failed to show prejudice as to her alleged oppressive pretrial incarceration or her anxiety. The Idaho Supreme Court has explained that these first two interests require a showing of legal prejudice. It must be more than claiming incarceration is unpleasant in a way that is common to most of the incarcerated population, and must constitute the excessive anxiety and concern Baker contemplates. Vallow has made no such showing. She argues that she was in jail or the state mental hospital for a set period. But that is common to most of the incarcerated population. They cite State versus Burke, analyzing being held in state hospital to being held in jail or prison. And she waived her claim that her anxiety increased because she faced the death penalty by failing to assert it in the district court. The second factor, to minimize anxiety and concern, has not been argued by Vallow. Even if not waived, she cites nothing in the record to support her appellate counsel's claim that she faced anxiety and concern on the basis that she faced the death penalty. Instead, the district court observed that any anxiety and concern she was experiencing had not affected her ability to cogently and rationally cooperate with the preparation of her defense. Conceding the proper time frame for the speedy trial analysis is 2 years. Vallow argues the prejudice portion of the analysis should consider the time she was incarcerated in 2 previous cases starting in February 2020. She is wrong. Speedy rights apply only to the same alleged offense. The 2 prior cases were based on different criminal charges. Even if those 2 previous cases would otherwise count towards her speedy trial rights in this case, Vallow fails to acknowledge in her opening brief that she signed waivers of her speedy trial rights in both previous criminal cases. So just a reminder, Lori was arrested February 20th, 2020 in Hawaii, and on March 5th, she was extradited back to Idaho. And the charges that she was initially arrested on were 2 counts of felony desertion and non-support of dependent children, and then 3 misdemeanors. And the misdemeanor charges were resisting or obstructing an officer, criminal solicitation to commit a crime, and then contempt of court. And that contempt was because she had a deadline to produce JJ and Tylee in Idaho, and she didn't. And Rob Wood was the reason she was arrested back in February. He did a lot of research and found a little loophole as to how he could get her in custody. So moving on, the 2 prior cases were based on different criminal charges. Even if those 2 previous cases would otherwise count towards her speedy trial rights in this case, Vallow fails to acknowledge in her opening brief that she signed waivers of her speedy trial rights in both previous criminal cases. She cannot now turn around and try to use the time she was incarcerated in those 2 cases against the state. Vallow has failed to show that any delay prejudiced her by impairing her ability to present a defense. On the contrary, as the district court explained, delaying the trial served to prevent unnecessary impairment to Vallow's defense because of the severity and complexity of the crimes charged and the large discovery in this case. And they cite Sutcliffe, finding this factor favored government where delaying trial allowed defense counsel necessary time to prepare defense. Vallow essentially concedes as much on appeal. They cite from her appeal brief, Ms. Daybell acknowledges that her counsel voiced concern about what they thought was the shortness of time to prepare. The 4th factor thus favors the state. And in Ish, it says holding prejudice factor favors the state where defendant fails to show prejudice. On balance, all Vallow has going for her on this claim is the length of delay, which runs face first into the indisputably complex nature of this case and the fact that she contributed to most of the delay, as well as her bare assertion of her right to a speedy trial. She has failed to show the district court erred when it found good cause under Idaho code for delaying the trial and rejected her constitutional speedy trial claims. So the conclusion, the state respectfully requests this court affirm the judgment of conviction. This was dated December 15th, 2025. So we'll see what happens. Don't think this is going anywhere. I think it's all going to hold, and this will be a big nothing burger. This is not something that came out of the blue. We expected the appeal, and there'll be more from Arizona. So that was it for the filing. I will keep my eye out for anything else that pops up, but I hope you guys have a good rest of your day, and we will see you soon.